Gabriel,
Yes, Chair.
we can let the people in. Huh? Yes, I can see
Ye-
the participants are
Yes,
coming in.
yes, we've started, and yeah, we are waiting for them to get admitted fully.
Okay, okay. Our speaker is
Some
here.
have,
We are
yeah, some
just
have dropped off.
setting up.
Perfect. Perhaps you'll give us a briefing then.
Yeah, I can see the 18 participants. Let me give a briefing in like 10 minutes because you had said there were 81 in the lobby.
All right. Okay.
Just let them in, then we'll brief them.
All right. Good afternoon, ladies and gentlemen. Thank you for logging in on time. My name is Gabriel from the Secretariat of the East African Law Society. Online, we have the chairperson of the Women Lawyers Committee, Madam Angela Munga Madumbo. She will be addressing us a little later and give us a brief of what the ground feels like. So as we wait for that and we wait for the ceremony to officially start, I am kindly requesting that we be a little patient as we wait for Madam Chair's communication. Madam Chair, so far we are online. We're waiting for others to log on. But in the interim, yeah, how is everything on ground?
Thank you very much, Gabriel. We are fine. Members, thank you for joining us this afternoon. Just give us 2 minutes, we finish, maybe like 5 minutes, we finish the setup because this is a hybrid event. So we have some members present physically. We ask for your patience. Just give us another 10 minutes, then we shall start officially. In the meantime, the chat box is active. You can introduce yourself in the chat box. You can tell us where you have tuned in from and what you seek to learn from this very exciting webinar. In the meantime, we ask for your patience for the next 10 minutes as we complete the setup. Thank you.
Thank you so much, Chair. And to our participants, as we wait, you can share the link to the webinar with a friend whom you know may be interested in the same. let's share and at least get as many people to benefit from this as possible. So as we wait for the setup, perhaps we could use this time to, share with a friend who knows a friend that may be interested in this area of strategic litigation. Otherwise, karibu sana, and we'll wait for the chair to come back and address us. Thank you.
We settle down, we are about to start.
Do the presentation. Okay.
Once again, good afternoon. For those just joining us, my name is Gabriel Achai. I am joining in live from the Secretariat of the East Africa Law Society. Would like to welcome you once again to this session. The setup is being complete on ground. On ground, we have the chairperson of the Women Lawyers Committee, Angela Munga Mwadumbo. Online is the trainer of the day, Mr. Kanyali Mwika. Will be starting off shortly. I request your indulgence as we finalize with the setup. In the meantime, I once again encourage you to tell a friend to join into the session so that we are able to start. So as we wait, you can tweet or share the link with a friend who has not yet joined that may be interested in this meeting. So otherwise, we thank you, and we'll wait for the for the chairperson to officially start the session, and then we'll take it on from there. Thank you.
Good afternoon, everyone. Just a minute, we sort the audio. I can hear there's an echo. Just 1 minute, we are starting. Good afternoon, members. I don't know whether I'm audible. No, I am.
Yeah.
No, I am not. Today, technology is proving to be a challenge. We thought we were on top of things, but
No, this is mine. This is complete. So,
Gabriel, confirm that you can hear me.
one of them, I just touch.
Hello, Angela. Yes, Gabriel, confirm whether you can hear me.
Yes, we can hear you.
Oh, thank you, thank you. Finally, we can begin this meeting or this event. It is my utmost pleasure to welcome all of you to this webinar stroke seminar. This is a hybrid event. So allow me to greet you for the fourth time today. Habari zenyu, bon après-midi tout le monde, and good afternoon, everyone. It is my distinct pleasure to welcome you to this event. We have some members here present physically. No, I don't even want to touch anything because of how long it has taken us to set up this event. So maybe the members who are here, just say hi. Yes, we have like around 20 members here physically, and we also have members joining us from the entire East African region virtually. It is my utmost pleasure to welcome you to this event. This has been made possible through the collaboration of the East Africa Law Society and KELIN. KELIN is an NGO in Kenya, and the word KELIN stands, the acronym KELIN stands for the Kenya Legal and Ethical Issues Network. This is a human rights NGO that is based in Kenya, and their core mandate is to protect and promote health-related human rights in Kenya. And they do this by providing legal services and support, training professionals and communities on health and human rights, and engaging in advocacy campaigns and which will influence policy. On the other hand, the East Africa Law Society is the Apex Regional Bar Association that was founded in 1995 by a group of like-minded individuals. Currently, we have 7 member states: Kenya, Uganda, Tanzania, Rwanda, Burundi, South Sudan, and the DRC has recently joined. So today's, before we get to today's topic, some housekeeping rules. If you have any question, we are going to have a plenary session after our speaker has finished with his presentation. So if you have a very burning question, you can post it on the chat section, on the Q&A section. The chat section is also live. That is where members can interact. We want to hear your views, observations, or comments on the webinar. After our presenter has finished his presentation, we are going to have a plenary session. If time allows, we can allow you to ask your question live, but if not, we encourage you to post your questions on the Q&A section. Without much ado, today our topic is litigating in the regional courts. Today we are talking about human rights. The reason why we want to understand how to litigate on the regional level is because human rights are universal. So we need to expand our skills to be able to litigate at national level and also at regional or international level. Our speaker today, we have the pleasure of having Mr. K. Kanyali Muikia, who is a human rights lawyer and a policy specialist with close to 10 years of experience in equality law, international cooperation on human rights, and social and economic rights in Africa. In previous roles, Mr. Kanyali has coordinated the regional advocacy strategy and action for the promotion and protection of women's rights in Africa, promoting minority rights in regional and international human rights forums, raising awareness on the pervasive role of sexism and ethnocentrism in Kenya's political system, and promoting efforts to democratize public policy making in a variety of local, regional, and international governance spaces. Mr. Kanyali is also a peer-reviewed researcher, author, and editor with expertise in social movements, strategic litigation, constitutional and comparative law, and international and human rights law. I think you will all agree with me that we are in very good hands. So because some of us are here physically, let us clap for Mr. Kanyali as he prepares to make his presentation. Karibu sana. Gabriel, confirm that you can hear our speaker.
I think they can hear me now. All right, hopefully we can avoid the echo for now, but thank you so much for that introduction, Angela. If you could switch on the camera for a bit, because the camera on my end seems to have stopped working. I can just wave to the virtual participants of this session this afternoon. Okay. Oh, yes, they can see me. Hi, good afternoon, everyone. And thank you so much for participating and attending. So today I'm going to be doing a small presentation just on regional mechanisms and litigating at regional mechanisms. And as my colleague Angela has just laid out before we start today, is that we litigate in these mechanisms because human rights are universal, and it's important to insist or emphasize on the need to protect human rights in these forums. So just going to the next slide. Today we are going, the main training session objective is that we want to enhance knowledge on how to engage with regional redress mechanisms. And the expected outcomes of the training is that we will have an enhanced capacity on engaging regional redress mechanisms in the defense of SRHR. And then we'll also have an enhanced awareness of existing SRHR case law coming out of regional courts. So on the second bit, the conversation really will be, I'm going to give just one main snapshot of a case that covers everything that you need to know about litigating in these mechanisms. And then I'm also going to provide other shorter summaries of past cases to just give you an understanding of what are some of the remedies you can seek in these forums. Thank you once again for your participation. In terms of the agenda for this afternoon, we are going to have a discussion until 3:30 p.m. on the regional redress mechanisms and their role in promoting and protecting SRHR. And then we will open the discussion for a Q&A and a plenary between 3:30 and 4:30 p.m. So today, because I usually I've worked with a lot of CSOs and NGOs in terms of kind of like accessing these regional mechanisms, I think that this is an opportunity for all of us to learn from each other, because at the end of the day, even when kind of like NGOs want to go and litigate in these forums, you have to rely on litigators, so lawyers who practice day in, day out. And so it is very important for litigators to have this enhanced awareness or understanding of what are some of the remedies you can get in these regional mechanisms and how you actually go about doing the litigation or kind of like engaging in litigation in these forums. So just to start us off, also keeping in mind the time, I'll start by just providing a brief definition of what these regional redress mechanisms are. And the redress mechanisms refer to legal institutions and processes established at the regional level to address human rights violations. And then these mechanisms, they provide avenues for a broad range of actors, so from individuals, groups, and organizations to seek remedies and justice for human rights violations within a specific regional context. So for example, the examples that I provide there for regional human rights mechanisms include regional human rights institutions. So for example, in Africa, we have the African Commission on Human and People's Rights, or the Office of the High Commissioner for Human Rights at the UN level. We have regional courts, regional dispute resolution mechanisms, and even regional parliaments, sometimes based on how let me just try again. Sorry, we're just resolving the issue of being able to see the slide. So I'm just going to try and stop sharing for just a minute to see if I can kind of like reshare again. Apologies for that. So I'm going to try again. All right. I'm trying to put it on the full slide share mode. Okay. So again, we were just talking a bit about, for our online participants, we were talking about some of the regional redress mechanisms that exist. And I was talking about how in certain instances, regional parliaments or regional administrative bodies can be a redress avenue or a redress mechanism. All it just needs is that, the treaty or the legal basis of that mechanism actually provides for a system where people can seek redress. So it's very important to emphasize that as well. And when we talk about, in Africa, we're in a very kind of like interesting situation, because for a long time, Africa has been considered a region, but then now we have what we call RECs, or regional economic communities, such as the East African Community or the South African Development, the SADC. So it's very difficult for us to know, like, where does regional start and where does it end? So usually I'll kind of like, for this presentation, what I will talk about, I'll talk about the mechanisms that exist at the East African regional level, as well as at the continental level. So for example, the African Court on Human and People's Rights, as well as the African Commission. So when we are talking about the significance of regional redress mechanisms, it's important for us to kind of like see why should you approach these mechanisms in the first place? What reason do you have for kind of like going to, for example, the East African Court of Justice when you already have national courts? And as you know, the discourse now is that at the national level is where implementation of human rights is focused. And I will say that the significance of these mechanisms, number one, is that they complement national judicial systems. So you'll find that, for example, if you've been unable to secure a certain remedy at the national level, at within national courts, you can approach these regional mechanisms because they actually are there to supplement national judicial systems. They offer alternative channels for justice. And these channels are very important when you've exhausted remedies or they're ineffective remedies at the national level. And so here I'll just kind of like take a break and perhaps give you an opportunity to reflect, what are some of the ways that a party in a litigation can exhaust local remedies? Who wants to answer that for us? And Angela, you can be keeping tabs on the chat box or Q&A if someone actually. Does anyone want to attempt an answer? Some of the ways I would say that a party in a litigation can exhaust local remedies, for example, is that, let's say you've had a human rights case, it started at the Constitutional Division of the High Court, maybe it didn't go the way you wanted, you appeal at the Court of Appeal, and then finally you go to the Supreme Court, and still the remedy that you're looking for has not been provided to you. That's an opportunity where you've already exhausted remedies at the national level, and you can actually now proceed to these regional redress mechanisms to see if you can secure justice in that forum. And as well, sometimes the national judicial systems can be quite ineffective. And this is especially in the sense where you're kind of like stopped from, kind of like exhausting local remedies. You'll find that in some jurisdictions, and this has been seen, for example, in Tanzania, that, for example, a human rights defender has been blocked from perhaps appealing a case, or the government, a particular government has made it difficult for you to actually exhaust remedies at the national level. For example, now, right now, I know in Israel, there's a lot of protests because the parliament there is trying to limit the judicial review powers of the Supreme Court. So for example, if that came to pass, perhaps it can render a remedy ineffective, and that means that you have to now pursue regional redress mechanisms to try and see whether you can secure, some of the redress that you need in that forum. And another good or significant aspect of these regional redress mechanisms is that they contribute to the harmonization and development of human rights standards within the region. And they also ensure consistency and coherence in the interpretation and application of rights. So for example, you'll find that because implementation from country to country, implementation of human rights provisions especially varies from one country to the other. And sometimes this is meant to reflect the local context where that human rights is being implemented. So you find that in cases where, especially at the national level, you find that it's very difficult for you to secure the full kind of like implementation of a right, what happens is that you can actually apply, or you can, approach regional redress mechanisms for the purpose of trying to kind of like get the government in question to harmonize its standards with what is provided, for example, by the African Charter on Human and People's Rights. So regional redress mechanisms are really helpful in harmonizing standards. So you'll find that, for example, the ECOWAS, there's a case at the ECOWAS court where the expulsion of pregnant school-going girls was found by Sierra Leone was found to be unlawful. That's now kind of like a standard that applies for the whole ECOWAS region. And you'll see in a case that was decided recently by the African Committee on the Rights and Welfare of the Child, that African Committee of Experts, you find that they actually relied on aspects of that decision of the ECOWAS court decision in trying to kind of like harmonize the practices by the government of Tanzania with what is expected at the continental or regional level. So very important in harmonizing standards. And perhaps you might ask, how do courts harmonize and develop human rights standards? Number one, they do this because they rely on a diverse range of legal sources. One of the things that I've realized based on just kind of like my work in human rights is that courts especially sometimes are very reticent to apply international legal provisions. And in Kenya, for example, there's a lot of discussion about the supremacy clause of the Constitution vis-a-vis how far we can go in relying on international human rights treaties. So you'll find that when you go to these regional redress mechanisms, it's already a question of the treaty law establishing the mechanism that they are going to apply international human rights treaties as part of their decision making. So there's no question about that, and there's no kind of like back and forth as to how far we need to implement a right that's provided, for example, in the International Covenant on Civil and Political Rights. So, and then another thing that regional mechanisms are really significant for is they rely on the expert perspectives of judges and adjudicators drawn from different legal systems. So you'll find that, for example, the African Court has a mix of judges from common law, civil law, and hybrid jurisdictions. So these are kind of like experts that are coming from a very diverse field. And that really, again, helps in harmonizing kind of like these standards that we are talking about today. So that diversity is really helpful in terms of securing justice in these mechanisms. Going to the next slide. And then, of course, just to continue, they promote accountability. Usually one of the main reasons why a lot of civil society organizations and litigants approach regional redress mechanisms is that they have enforcement protocols that leverage the political power of multilateral and intergovernmental organizations. So for example, when it comes to communications that are sent to the African Commission on Human and People's Rights, what you find is that there's a mechanism for enforcement. Governments have to report what steps they've taken to implement a particular decision of the African Commission. And also there's this, it's very controversial at the AU level, where they have a name and shame list of every country which has not implemented a particular decision. And that list is kind of like, has to be confirmed by the Executive Council of the African Union. So there you see that the African Commission is relying on the political power of the AU to ensure that the decision in question is actually implemented. And of course, they use a range of a range of tactics and tools, again, the name and shame, as well as, kind of like requiring states to report on how far they've gone in implementing a specific decision. Another thing is that regional redress mechanisms strengthen cooperation. So because these are, first of all, when you look at the treaty, the human rights treaty system, number one, you can only be bound to, for example, the African Charter, because as a president of a country, you signed it, and then it was ratified, and now you're in the process of domesticating the treaty. So you can't come and say that, I don't want to be bound by this unless you put in a reservation. So you'll find that that kind of like cooperation at the the continental and regional level is very important in providing legitimacy to these regional redress mechanisms, especially when you're pursuing a case because the remedies at the national level are ineffective or you've already exhausted them. And again, that's what I try to emphasize down there, where I say that many regional redress mechanisms are treaty-based. You've agreed to promote and protect human rights. And then, so this adds an extra, treaty law adds an extra layer of obligation. At the end of the day, the big thing that binds a lot of governments to human rights provisions is the constitution. But then you have an extra layer when it comes to, treaties, human rights treaties. And of course, it expands access to justice. It enhances access to justice for marginalized and vulnerable groups who often face barriers in accessing national courts. And this is very important to note when we're talking about SRHR, because some of the cases that I'm going to be talking about today, you'll find that the groups in question or the litigants in question were quite marginalized at the national level. And so it was important for there to be a mechanism which they can rely on without a lot of restrictions that have been placed on them at the national level. I will park that question, the plenary, on some of the ways that marginalized and vulnerable groups face barriers when accessing national courts. But in my experience, I've seen everything from intimidation and threats, human rights defenders being deported from the country. So they are kind of effectively blocked from accessing these remedies, and so on and so forth. And of course, there are also practical limitations when it comes to deciding to pursue a case that might direct you to pursue the case in question in a regional redress mechanism. So today I'm going to be talking about 4 mechanisms in particular, and that's the African Court on Human and People's Rights, the East African Court of Justice, the the African Commission on Human and People's Rights, and the African Committee on the Rights and Welfare of the Child. These are the three main mechanisms for redress when it comes to human rights violations in the region. Of course, we have other mechanisms, for example, the COMESA Court, but that touches on issues to do with like trade and business disputes. And this one is mostly where, like, if you're an individual litigant or if you're a non-governmental organization, these are the main forums for you. Yeah. And then, of course, I'm going to talk a bit about the African Court. The African Court was established by the AU in 1998, and then it became operational in 2006, when the protocol establishing the court came into force. I think the rules were that as after 15 countries had signed on and ratified the treaty, it came into force. And just to kind of like talk about the contentious nature of how, you know, countries were so unwilling to bind themselves to the court, it took 8 years for the treaty to become effective. So it took 8 years for 15 countries to sign on to the treaty. The African Court is mandated to hear cases related to human rights violations committed within AU member states. So of course, every country in like the East African Community region, you can approach the court because all the countries are AU member states. And then crucially, the jurisdiction covers both individual and state applications. Cases can be brought by individuals, NGOs, and AU member states. It's rare that I don't think that there's a case at the moment where a country has kind of like taken another country to the African Court, but that's an opportunity that's made available to states. And then, of course, it's very important to note that individuals or groups must exhaust local remedies before approaching the court, unless those remedies are unduly prolonged or unavailable. And I'm going to talk about a case where that's going to be, we're going to talk about like the undue prolongation of the remedy or the unavailability of the remedy. We've already talked about some of the practical things that can block you from accessing a court. So the composition of the African Court is 11 independent and impartial judges elected by AU member states, and they serve a 6-year non-renewable term. Again, these are judges who are drawn from all the countries of Africa. So you'll find a lot of like diversity in terms of nationality, language, religion, and also jurisdiction in the composition of the court. So the functions and powers of the courts, of course, is adjudicating cases alleging violations of human rights. These are human rights that are protected under the African Charter and other relevant human rights instruments ratified by member states. This is very important to note because one of the main ways in which the African Court considers cases to be inadmissible is that sometimes you're talking about rights that are not covered under the African Charter. I mean, you can bring because human rights is always evolving and developing. There are a lot of protocols to the African Charter that cover these issues. And then, of course, it interprets and applies the provision of the African Charter and other relevant human rights instruments. It can issue advisory opinions on legal matters related to the African Charter and other instruments. It can order reparations, and then it also has a mechanism for monitoring the implementation of its judgments and decisions by member states. Very important to note that because, as you know, strategic litigation does not end when you win or lose a case. There's a lot of activity that happens after a case has been concluded, and implementation of a judgment is one of the key post-litigation activities you can engage in. Again, we've talked about access to the court. Who can access the court? Individuals, NGOs, and AU member states can access the courts. The courts also have guidelines and procedures for filing applications and presenting arguments before the court. So now yes. Really? Gosh. Let me try again. Okay, so now we are talking about the East African Court of Justice. So the EACJ, of course, was established by a treaty. The treaty was passed in 1999, and then it commenced its operations in 2001. The EACJ is mandated to ensure adherence to the law in the interpretation and application of the EAC treaty. The jurisdiction, again, covers disputes between EAC member states, as well as cases involving individuals and legal entities. Gosh, sorry, someone is calling. Jurisdictions, it also protects and enforces the fundamental principles of the East African Community, including human rights. Remember that the East African Community Treaty has a big kind of like human rights component. And so that's where the suitability or significance of the court in adjudicating human rights matters comes in. Again, the EACJ is composed of judges appointed by the summit of the EAC heads of state, who serve for a renewable term of 5 years. The court comprises a principal judge and other judges from each EAC member state. Let's continue. Right. Who can access the courts? Again, individual applicants, any person who is a resident of an EAC member state can bring a case before the court. And then we also have provisions for state applications, so meaning EAC member states can also approach the courts. For some reason, I forgot to add that, but also non-governmental organizations can approach the EAC, as long as you say, you know, like you have an office or you have a presence in the region, or the subject matter is located in the jurisdiction of the EAC court, you can approach the court. Important to note that the decisions of the EACJ are binding on the parties involved and must be implemented by the respective member state. And of course, to ensure that happens, it has mechanisms in place to ensure compliance with its decisions, including referral to the EAC Council of Ministers for appropriate action. You see, that referral is a big kind of like deal for member states who don't. The human rights system, I will say, is really premised a lot on naming and shaming. So kind of like, you know, if you violate human rights as a country or as a state, like the naming and shaming aspect is very important. And so that's why the referral mechanism being based at the EAC Council of Ministers, which is an executive arm of the EAC, is very, very important to kind of like bring that political leverage back into the picture. And of course, like, you know, if there's a referral to the EAC Council of Ministers, theoretically, they can also kind of like consider sanctions that can be placed on a particular country. But that, I mean, given the political state of affairs, that would be a hard sell, a tough sell for the EAC Council of Ministers, but it is something that is kind of like, it's, what's the word I'm looking for? It's something that you can do. It's kind of like, I'm losing the word, but you can conceptually, you can go all the way to sanctions, yeah. Okay. And then we have the African Commission on Human and People's Rights, the ACHPR. So the ACHPR was established in 1987 under the African Charter, which was signed in Banjul. So it's also known as the Banjul Charter. The ACHPR is a primary regional human rights body within the AU system. The mandate and functions of the ACHPR. The ACHPR has what is known as a promotion and protection mandate. So it promotes and protects human rights in Africa, including SRHR. It monitors the implementation of the African Charter by member states and assesses their compliance with human rights obligations. It receives state reports on human rights. It conducts country visits and provides recommendations to member states on improving human rights. For this particular conversation, I won't go into all the nitty-gritties, especially when it comes to provision of recommendations, but those are usually posted in the state reporting system where governments are supposed to kind of like give a report of the implementation of human rights within their countries. And then based on the report and also based on the reports by NGOs who shadow the state report, it issues recommendations. The Commission also can conduct public inquiries into human rights violations. I think a big inquiry that it has been doing for a couple of years now has been the inquiry on the armed conflict in the Tigray region of Ethiopia. So that has been one of the things that it has been doing. And then also it interprets the provisions of the African Charter and issues guidelines and recommendations for its implementation. So for example, you'll find that it has guidelines, and these have been very instrumental in recent case law in Kenya on matrimonial property, or how you kind of like divide property upon, you know, kind of like divorce or annulment of a marriage, divorce, separation, or annulment of marriage. So that's just kind of like an overview of the SHPR. The SHPR has a communication procedure, and I just want to take a brief pause here to say that the communication procedure for litigants, this is the main redress mechanism within the SHPR, the communication procedure. So you'll find that the SHPR receives and considers individual complaints of human rights violations, and these can be submitted both by individuals or NGOs against state parties to the African Charter. I think as far as the last time I checked, the only African country which is not a party to the African Charter, I think has to be Morocco, and this is because of the whole Sahrawi Arab Democratic Republic issue. But even that country, from what I've heard, they're in the process of actually signing the African Charter now that they've been allowed back into the AU. And the SHPR, of course, can receive complaints from one state party against another state party for alleged human rights violations. Again, because of the political cohesiveness among African states at the AU level, it is rare, and I think it will take a very long time before we see a case where one state party like sues another state party for alleged human rights violations. But this is not unknown, because as you remember, the Gambia actually pursued a case at the ICJ for genocide against the Rohingya population. So one day we'll get there. And then the commission determines the admissibility of complaints based on a specific criteria, including exhaustion of local remedies and timelines. So you'll find that this is a major issue that comes up in regional redress mechanism case law, that in addition to exhausting local remedies, so these are remedies at the national level, you also have to kind of like bring the case in a timely fashion. So you didn't take too long before bringing in a case at the African Commission. And usually the timeliness rule is limited. After 7 years, it's almost impossible for you to bring a communication to the SHPR. And of course, if a complaint is admissible, the SHPR can make recommendations to the state party involved and provide remedies for the violation. Some of the remedies that have been provided by the SHPR include reparations to individual litigants. The recommendations go from everything from recommending the state to repeal a law, or actually recommending the state to implement the provisions of, for example, the African Charter in a very particular way. So how does the SHPR cooperate with other African Union organs? Number one, collaborative efforts. The SHPR works closely with other EU organs, such as the African Court on Human and People's Rights, to promote and protect human rights in Africa. If you read up on this issue, you'll find that there is a complementary mechanism whereby like cases which began at the African Commission can actually be escalated to the African Court and vice versa. And they also have regular interactions where they kind of like come up with ways of being compatible with each other vis-a-vis who is accessing the redress mechanism in question. The second bit is that the Commission engages in joint initiatives with regional and international human rights organizations to address human rights challenges collectively. So from my own experience and my observations, I do know that they have a direct kind of like working relationship with the Office of the High Commissioner for Human Rights at the UN, as well as the Inter-American Commission on Human Rights. And I think the main focus of their engagement is on the rights of human rights defenders. And also just kind of like learning best practices from each other. The last bit is that the SHPR monitors state compliance. Again, it interacts with member states and encourages them to implement its recommendations and decisions. So again, the recommendations, usually when a country files a state report with the Commission, and the Commission goes through the report, finds where the gaps are, and then it gives recommendations to the country on how to implement human rights in a more effective or impactful manner. So you'll find that monitoring state compliance is a big aspect of the work of the ACHPR. The ACHPR also does a lot of country visits. I think the last major one that they did was a country visit to Tanzania to meet the president, and just to kind of like keep the relationship going and keep the relationship cordial. What is the impact and influence of the ACHPR? Number one, advocacy and awareness. The ACHPR plays a critical role in raising awareness about human rights issues, including SRHR, through its reports, resolutions, and public statements. So a big way in which the ACHPR actually develops the legal kind of like environment for enforcing human rights is especially through its resolutions and also through its reports, where it kind of like clarifies further the specific way in which you're supposed to implement human rights provisions that exist in the Africa Charter. Number two, normative development. It contributes to the development of regional human rights standards and principles through its interpretations and recommendations. So you'll find that a lot of people, and even in some of the cases we're going to be talking about, even though the redress mechanism, for example, is the African Court, you'll find that they're still relying on some of the soft law provisions that have been developed by the African Commission. And number two, collaboration with, the last point there, collaboration with civil society. The ACHPR works closely with CSOs to enhance their capacity in protecting and promoting human rights. When we say their capacity, we mean the capacity of the African Commission. That there's a lot of kind of like interactions with CSOs who usually have a lot of expertise that the Commission relies on in developing and also enhancing its work. And of course, one of the main ways in which the ACHPR collaborates with CSOs is through the convening of ordinary sessions. There are usually 2 ordinary sessions every year. And there are also opportunities for CSOs to engage with the ACHPR during its intersession period, which means the period between the ordinary sessions. As I spoke about, the ACHPR again, it carries out country visits and consultations with CSOs. So they always kind of like have opportunities where you can consult as a civil society entity with the ACHPR. Moving on, now we've gotten to our last forum, which is the African Committee of Experts. I forgot to add of experts there, on the rights and welfare of the child. This was established in 1999 under the African Children's Charter. It is a specialized body within the AU responsible for promoting and protecting the rights and welfare of children in Africa. And this was a big landmark kind of like move, when the African Committee of Experts was established. So yeah, what are the mandates and functions of the Committee of Experts? Number one, it monitors the implementation of the African Children's Charter by member states and prepares reports on the status of children's rights. So if you're kind of like a litigator with us today who's really, really interested in the rights of children, you can kind of like try and look at the work of the African Committee of Experts, because again, they're a committee of experts. They do a lot of the work in kind of like developing soft law provisions vis-a-vis children's rights. So there's a lot of information for you there. Again, the Committee of Experts reviews periodic reports submitted by member states and provides recommendations on measures to improve the realization of children's rights. It has a communication procedure, just as with the African Commission on Human and People's Rights. I don't know why they called it communication procedure. It's just litigation. So they call it a communication procedure, but when you go there, it's Kanyali versus Angela. So it can, the communication procedure, it can receive complaints of violations of children's rights submitted by individuals, groups, or NGOs. Some of the biggest kind of like decisions that are coming out of the Committee of Experts is, for example, the Senegalese Talib case, where like, you have 100,000 children who are given up by their parents to go and work for these religious institutions in Senegal. And then their right to education is curtailed, and then they are forced to kind of like beg in the streets so that they can raise funds for these religious institutions. And of course, it does public inquiries, so the committee can initiate public inquiries into specific issues or situations affecting the rights and welfare of children. And also, it does a lot of collaboration and advocacy, meaning that it collaborates with governments, CSOs, and other stakeholders to advocate for children's rights and promote their welfare. As with the African Commission, there's also a lot of engagements with CSOs. So it usually has its own ordinary session. And I think that one is once a year, if I'm not mistaken. So it's an opportunity for CSOs, individuals, public institutions, and governments to interact with the committee of experts. Let's talk a bit about the reporting and accountability. So when we talk about redress, again, it's not just litigation. You have to kind of like look at it a bit more holistically. And when we are talking about reporting and accountability, we have state reports. As I've spoken about, member states are required to submit periodic reports to the Committee on Measures Taken to Implement the African Children's Charter. It does a lot of concluding observations as well. So it provides recommendations and observations to member states based on the review of their reports. And again, this is if you're especially working in the CSO sector, there are a lot of like recommendations, policy recommendations in these concluding observations that you can rely on as a basis for your advocacy. And of course, it has follow-up mechanisms, so it monitors the implementation of its recommendations and engages with member states to ensure accountability. And when you remember that this is an AU organ, again, it's leveraging the political power of the African Union to compel states to respect the rights that they themselves have agreed to be bound to. So what is their communication procedure looking like? Again, communication, it's just litigation. Individual complaints. So the committee can receive individual complaints alleging violations of children's rights under the African Children's Charter. Again, one thing that's really important to note is the admissibility criteria. So the committee is the one which determines whether your case is admissible, as is the case with all judicial and quasi-judicial mechanisms. So it determines the admissibility of complaints based on a specific criteria, including the exhaustion of local remedies and timeliness, just as with the African Commission. And we will be looking at a case where this actually came up. And of course, it gives recommendations and remedies. So again, if a complaint is admissible, the committee can make recommendations to the state party involved and provide remedies for the violation of children's rights. And here, when we talk about remedies, it's important for us to talk about and I mentioned this before, this means reparations. So the committee or the African Commission gives you gives the government an order to pay reparations, but it can also go and say that, oh, you need to enhance your child protection framework in this particular way to address this particular human rights problem that, your country is experiencing. So just to note that as well. How does it collaborate and coordinate with other organizations? Just as with the African Commission, it collaborates with other AU organs such as the African Commission and the African Court to strengthen the protection of children's rights. And when it comes to this synergistic working relationship, there has been a case that has actually been declared inadmissible by the African Court, because the African Court determined that the Committee of Experts is a parallel organization, or is kind of, what's the word? It's an organization with the same kind of like powers and mandate and abilities. So once a case has been decided at the committee level, the African Court can say, okay, this case has already been decided and we can move on. And then again, cooperation with stakeholders. It works closely with governments, CSOs, and international partners to promote and protect children's rights in Africa. If you've been sufficiently kind of like interested in the work of the African Committee of Experts, you can try and apply for a position there. They're based in, I think it's in Lesotho. And, that's where they based their operation. And, like there was a lot of discourse. I think this was in the 90s where Lesotho really wanted to host the headquarters of the African Commission. and then they didn't win the approval of other countries to have the HQ there. And so they redoubled their efforts the second time around. And now the committee of experts is headquartered there. What is the impact and achievement of the committee of experts? Number one, normative development. Again, the committee of experts looks into the entire gamut of like child protection or kind of like, treaty laws on the rights of children, and then it creates norms that all states are bound to. And then it also strengthens child protection systems. You'll see that, for example, in the case I was just talking about, where it was discovered, that Senegal was actually allowing the violation of the rights of hundreds of thousands of children by allowing them to kind of like be taken in by these religious institutions who are not providing them with adequate care or adequate opportunities for education, health, and social development. And lastly, we have advocacy and awareness. It plays a vital role in raising awareness about children's rights and promoting their inclusion in national agendas. So because it's a big forum, it's a multi-governmental forum, and there are a lot of people interacting with it, any issue that's picked up by the African Committee of Experts, like by default, it kind of like gets a lot of currency within the kind of like, human rights discourse, and there's a lot of awareness about its work in the human rights sector in Africa. So now I'm going to just take a break there and move on to the next bit about the importance of litigating SRHR in East Africa. Of course, SRHR encompasses a range of human rights related to sexual and reproductive health. So some of the key components of the SRHR, of course, is the right to the highest attainable standard of physical and mental health. And as you know, like, for example, in our constitution, reproductive rights is clearly spelled out. You have the right to autonomy and privacy. So you have the right to make decisions about one's own body, reproduction, and family planning without coercion or discrimination. You have the right to information and education. So access accurate and comprehensive information, and to receive appropriate education on these matters. I will say from my own experience, like working in human rights and specifically on the rights of women and girls in Africa, part of like what drives a lot of like the challenges that we are seeing, high rates of teenage pregnancy or child marriage, and also maternal kind of like mortality and morbidity, is because a lot of the users of these services are actually not getting appropriate information that is aimed at enhancing their health access or preventing them from getting into like situations which compromise their health. So the aspect about information and education is quite important. And of course, there's the right to non-discrimination. So SRHR includes freedom from discrimination, especially when it comes to sexual and reproductive health. We are talking about health at the end of the day, and it's important to kind of like reiterate that no one is like exempted from the right to health. So the right to health should be provided without discrimination. And of course, the right to consent, you have the right to free and informed consent for any medical procedures or interventions related to SRHR. And you'll find that this is one of the cases that I'm going to be talking about, goes into the bit about informed consent. So what are the kind of like international legal frameworks that undergird SRHR? So of course, we have the international human rights instruments. For example, we have the UDHR, which is the Universal Declaration on Human Rights, the ICCPR, the International Covenant on Economic, Social, and Cultural Rights. And then we have the Convention on the Elimination of All Forms of Discrimination Against Women, or known as the CEDAW Convention. At the regional/continental level, we have the African Charter, the Maputo Protocol, and the African Charter on the Rights and Welfare of the Child. And of course, we have the element that I was talking about, which is international soft law, which for me is soft law in the form of declarations, standards, guidelines, and resolutions by human rights bodies, as well as case law from international or regional redress mechanisms. These also have their vital source of guidance on how to effectively implement SRHR at the national level. For those who are interested in kind of like expanding their knowledge base about SRHR, it's very important to look at international soft law because it teases out issues that were not necessarily or adequately covered under treaty law, but they've become more apparent as time goes by. What is the importance of promoting and protecting SRHR? Number one, empowerment and gender equality. SRHR are essential for promoting gender equality and empowering individuals to make informed choices about their bodies and lives. There's also the public health impact. I've just spoken about high rates of maternal mortality and morbidity, high rates of, kind of like sexually transmitted infections and so on and so forth. One way of kind of like reducing this great deal of human suffering when it comes to, for example, maternal mortality is by providing comprehensive SRHR services. And also the public health impact goes all the way to SGBV by kind of like educating, especially women and girls, about how kind of like awareness about their rights can actually contribute to reducing or addressing SGBV. And finally, promoting overall public health. Sexual and reproductive health is health. It's not different from kind of like taking a Panadol for a headache. It's part and parcel of our conception universally of what health is. And then finally, we have sustainable development. So ensuring SRHR is critical for achieving sustainable development goals related to health, gender equality, and human rights. I think it's apparent to see just once you kind of like look at the, again, great deal of human suffering that's reduced just on account of providing rights that are clearly articulated under international and national law. So here we have, why is it important to litigate SRHR in East Africa? Number one of the main reasons why us who engage in this work, I think one of the main reasons we get into this work, number one, is because it is apparent to see that many individuals face barriers in accessing affordable quality SRH services, including contraceptives, maternal care, and HIV prevention and treatment. Kind of like litigating SRHR helps address stigma and discrimination. So there's a lot of stigma, especially in the East African region, about abortion, HIV, and even the act of seeking SRH care in the first place, which can prevent individuals from seeking necessary healthcare services and information. And number three, we have the aspect of legal restrictions. Some countries in Africa, and many of them in the East Africa region, have restrictive laws and policies that hinder the realization of SRHR. Even in the case of Kenya, where like SRHR is provided for under the Constitution. So for example, we have laws that criminalize abortion. We have restrictions placed on SRH care providers. And this can be, for example, we know of cases where the government of Kenya, for example, has threatened professional consequences, quote unquote, for people providing services that are provided for under our Constitution. And of course, we also have laws that place restrictions on pregnant school-going children. You have HIV-related criminal laws, or what I describe as statutory silence on issues such as surrogacy or assisted reproduction. So where you just find that the laws in place do not address this issue that is very present in our society. And the law just kind of like policymakers refuse to address certain issues. So I had a question here, and colleagues, you can put it on the chat box, or you can save this for the plenary section, which is that, have you witnessed or experienced some of the challenges described above? And what other challenges and violations exist when it comes to accessing SRH services? So let's talk a bit about the role that litigation plays in advancing SRHR. So all of us, or most of us in the room today, are lawyers, litigators, or legal professionals. So we know what litigation is, which is a process of seeking legal remedies through the court system to address rights violations. Part of why litigation can be a good tool in advancing SRHR, of course, is because a lot of the cases that are done in this sector, number one, relate to seeking legal recognition, protection, and enforcement of SRHR. So what is the strategic use of litigation? We've been talking about, especially in Kenya now, there's a lot of conversation about what is known as strategic or public interest litigation. So successful litigation establishes legal precedents that can be used as tools for future cases, which provide a foundation for advocacy and legal reform. Litigation can be strategically timed to coincide with policy discussions, legislative processes, or international events to maximize impact and influence. And of course, the thing that makes strategic litigation strategic is you are identifying what, focus on the specific legal issues of vulnerable populations affected by SRHR violations, because that helps focus efforts and achieve targeted outcomes. And then the last point in this slide is that strategic use of litigation enables you to engage in strategic alliances with NGOs, activists, legal experts, and affected communities. And this, of course, strengthens litigation efforts and expands the reach and impact of advocacy. Now, let me check how much time I have before I have to be done. Oh, gosh. All right, I will do my best. So we've talked a bit about litigation. Strategic litigation, I think it bears, distinguishing between the normal litigation that lawyers engage in. So the normal litigation is, Kenny, the client, comes to you and is like, I want to sue this person. I'll give you a story and it's you to kind of like draft, how you're going to do it at the court. But strategic litigation is much more than that. It requires you to think deeply about what your stated goals are. And it also requires you to think deeply about some of the approaches or strategies that you're going to implement to secure justice for a particular client. So because we've had the benefit of centuries of legal precedent on conventional forms of litigation, it's much easier to kind of like carry out conventional litigation. But strategic litigation, because it's, I think like even in countries where like they've had PIL, it's just been like, common law goes back thousands of years, but PIL, day-to-day strategic litigation is perhaps maybe a century old. So like I'm thinking about the Dred Scott decision, for example. So it's not as old as, it's not as old as conventional litigation. So some considerations when you're engaging in strategic litigation, you have to kind of like look at how you're ensuring equitable access to justice, particularly for marginalized and vulnerable groups. You have to think about what resources you'll need. For strategic litigation, conventional litigation, I go to my lawyer. I'm like, this person already has a degree. They've been added to the bar of their particular, jurisdiction. So I just kind of like go and I assume that you have the expertise necessary to kind of like carry on a litigation. Or if you don't, it's very easy to overcome that learning curve when you're performing conventional litigation. But for strategic litigation, you really have to think about the resources, the legal expertise, financial support, access to evidence, and these can pose challenges in pursuing cases. And then strategic litigation is different from conventional litigation in that it should be complemented by broader advocacy and mobilization efforts to build public support, change social norms, and address systemic barriers, for example, to SRHR. Again, I have a plenary question there that I don't think I'll get time to answer, but some of the, think about some of the challenges and considerations you should keep in mind while pursuing litigation, strategic litigation in defense of SRHR. Really think this has to be a very reflective process for you. You have to sit down with yourself and ask yourself, what do I have on my side that will empower me, for example, to win a case? And when we talk about even winning a case, what does winning look like? So you have to have a very clear, picture on the goals. I'm going to rush through this because I think I've captured a bit of this in my earlier parts of my presentation. Again, why is it important to litigate at regional courts? Number one, you're shaping legal standards, you're challenging discriminatory laws and practices, you're establishing rights-based approaches, and also you're ensuring accountability and amplifying public discourse. Again, the thing that distinguishes strategic litigation from conventional litigation is that sometimes you're almost kind of like you have to see the benefits of doing the case at the, kind of like in the courts of law and also in the courts of public opinion, so that you can kind of like create that public awareness. And the good thing about that is that even if you lose a case, sometimes you might be lucky enough to get so much public awareness that the government feels compelled to actually, kind of like move on with implementing some of the popular, themes that are being proposed in your case. So, and also I think the element of sparking dialogue and debate is also quite important. Sometimes people don't think about these legal issues, but then strategic litigation helps in kind of like bringing awareness about a particular theme. How do you prepare a case for regional redress mechanisms? Again, the difference between conventional and strategic litigation is what you do in your quest to kind of like secure justice for your client. So for conventional litigation, sometimes, a defamation case is cut and dry. Like you just have to figure out the case, you look at the legal provisions in question, and then you kind of like start thinking about what remedies you're going to seek. But in, like strategic litigation, especially at the regional redress mechanism level, you have to be very careful to identify strong and impactful cases. So strong and impactful cases is very important in strategic litigation. So for example, in the case of SRHR, it starts by assessing the SRHR landscape in your country. So that enables you to identify areas of concern or violations. I think it's important to engage with affected communities as well. The thing that really sets strategic litigation apart as well is research and data. So like in your case selection and preparation work, you have to look at reviewing, you have to review existing reports and data to kind of like look at what is the data backing for the case at hand. And then it's good to do media monitoring to see whether there is press coverage about the specific issue that you care about. And then again, because strategic litigation is so distinguished from like conventional litigation, there is a big role that is played when it comes to involving legal experts and organizations. So number one, a lot of SRHR cases, or sorry, strategic litigation cases involve like expert evidence. So you have legal scholars who are well versed in the issue at hand. You have litigators, and finally you also have CSOs who are focused in the thematic area that you care about. And the good thing about having all these kind of like resources is that you are able to actually look at potential legal avenues, strategies, and regional redress mechanisms available for SRHR litigation. I have 1 minute to go. So again, when you're identifying a potential case, I think that it is important to look at the strength of legal arguments and evidence. Strategic litigation, again, the distinction between conventional litigation and PIL is if a client wants you to pursue a case in a conventional dispute, legal dispute, you just kind of like go along with it, win or lose. But because when you're accessing these regional redress mechanisms, you really want to win, you have to like have an honest discussion. You have to have a meeting with yourself, as we say, where you look at the strength of your legal arguments and the evidence. You have to look at the potential for impact and setting legal precedent. You have to look at where is the availability of affected individuals. because rarely do these regional redress mechanisms take hypothetical cases. And so it is important to look at that. You have to look at whether your case is strategically aligned with regional and international human rights frameworks. And then, of course, you have to look at consideration of risks, including potential backlash or reprisals. For those who are kind of like active in this sector, you know that there's usually a lot of backlash and reprisals, especially for very controversial cases. I think in Kenya recently, we had a Supreme Court decision which led to a lot of backlash, like, you know, on the freedom of association of LGBTQ organizations. Just an example, but when you're a strategic litigant, it's good to look at, like, what is the risk of pursuing this case? What happens if I lose? What happens if I win? Very important. Again, gathering evidence, the best way to do it, again, you have to look at the regional legal frameworks or the relevant legal frameworks. What do they say, or what do they talk about when they're like saying, this is the evidence you can bring in and this is the evidence you can exclude? You have to go again and building a strong argument, you're reviewing the national laws and policies and assessing the level of their implementation and enforcement. You have to conduct a lot of legal research, actually comprehensive legal research. With a lot of these cases, you can't kind of like, before you submit a case, every answer or every question that you have, like in the legal dispute at hand, it has to have a comprehensive answer. You can't go into, for example, the African court with the word maybe as an answer to a question. So you have to be very, very certain about the approach that you're taking. I think it's also important, again, collecting empirical data and expert opinions. You have to document human rights violations, and that goes back to collecting empirical data. You have to engage with CSOs and independent experts so that they can give you another perspective or another view to the kind of like to the case that you have. Everyone here, like, especially if you have a legal background, you know that once, especially once a client has attached themselves to a particular legal interpretation or an interpretation of facts, it's very difficult to divorce them from like that narrative that they have. But you don't have that opportunity when you're doing strategic litigation. You just have to kind of like get an independent expert, and you have to listen to them when they say that this is not a winnable case, or like this case could actually go the opposite direction for you. So that's important to have independent experts giving their voice. You have to find a way for organizing and presenting evidence. And then, of course, crafting the legal argument itself. And of course, as always, you have to anticipate counter arguments and address them proactively. So again, conventional litigation, because we have so many years of precedent, you already have a system for how you're going to argue, or you're going to craft your arguments. But then when you're doing a lot of strategic litigation, because these are sometimes new issues which have been unaddressed, it's very important for you to think about what counter arguments the opposing side might have. And this also teaches you like not to be surprised, like it prevents you from being surprised by an outcome of a decision. So again, selecting the appropriate redress mechanism is very important. So number one, you have to kind of like really think seriously about what forums are available to you as a litigant or as a litigator. And you have to ask yourself, what am I looking for? What am I looking for out of this decision before you actually choose the forum where you're going to pursue the case at? So for example, here we have, again, you look at how to select the mechanism. Number one, you analyze the specific SRHR violation, for example, and align it with the mandate and the jurisdiction of the regional redress mechanism. Usually, a lot of these regional mechanisms have rules as to which cases they can accept and which cases they can't accept. So that really, really helps you in figuring out the forum choice. Again, you have to consider the legal and strategic advantages and potential remedies offered by each mechanism. So for example, the redress is different. It looks different at the ACHPR level than it does at the African court, just saying. And then you have to assess the capacity, resources, and expertise required for engaging with a particular mechanism. And this sometimes, if you think seriously about this, it can lead you to perhaps pursue cases, for example, at the UN level, which has far more resources than regional or continental redress mechanisms. And then other strategic considerations that you should take in mind. Number one, you have to evaluate the potential impact and influence of the chosen mechanism. So how often are there, decisions implemented? How scared is the government like to appear before this court or this mechanism in the first place? Which mechanisms perhaps do they respect more, or that whose decisions they implement more effectively? And then also you have to consider the opportunity for setting legal precedents. So in which forum does it make more sense for me to pursue a particular redress? So you have to look if the main goal of your litigation is to set a legal precedent, that's something that you really, really need to think about before choosing a particular mechanism. And of course, what is the opportunity for collaborating with legal experts, CSOs, and affected communities to inform the selection process? So for example, if there's a court which is like 2,000 kilometers away and everyone has to give testimony, witness testimony in person, do you have the funds to kind of like shuttle all these people to that country to give that evidence? So those are some of the practical considerations that you think about. I think it's important, if you're interested in litigation, to come up with a litigation strategy. I'm not going to go in depth into this, but having a litigation strategy is important because it helps you define the objectives. Why are you litigating? What is a targeted redress mechanism or mechanisms? Usually, like, it's good to have an encompassing strategy. And then what are the legal and practical considerations of litigation? For example, will my clients have to travel 2,000 kilometers back and forth to give witness testimony? Do they have the funds to kind of like accommodate themselves in these countries? You have to think about what is your legal argument for pursuing litigation. You have to come up with a way for engaging stakeholders and affected communities. You have to have a communication and advocacy plan for like how you're going to communicate how the case is going. And then you have to have a question for managing risks and mitigating challenges. So that's very important as well. What are the risks of you pursuing this case? What are kind of like, for example, the risk of reprisal, the risk of losing the case, and what that might mean for the work that you really care about. And then, of course, you have to have a system for monitoring and evaluating the progress and sharing lessons learned with partners. I would say that as a litigator, you shouldn't really pursue strategic litigation without this litigation strategy, because litigation strategy, you can't learn on the job for the most part. If you make a mistake, it means that you've lost the opportunity to set a precedent, or you've lost reparations for your clients. This is sometimes the very last redress mechanism available to your client. So you really have to be serious about coming up with a litigation strategy. And of course, I don't know if I'm going to go into this, but you have to think about how to, mobilize public support and raise awareness. So, this means you have to come up with a plan for how you're going to communicate the work that you're doing, or the progress of the litigation. You have to tailor your messages to diverse audiences, especially if your strategic litigation has an advocacy component. You have to figure out how to engage with traditional and social media. Do you want to organize public events and campaigns? How do you want to engage with affected communities? I've just spoken about a case in Senegal where you're thinking about But at this point, do you?
Members, as our speaker powers up his machine, we have a chance for plenary. We have 2 hands up in the hall here physically. Online members, if you have a question, either put it on the Q&A section or you raise your hand, we shall enable you to talk. Because there are people here who are raring to ask the question, you can proceed, you tell us your name first, then you ask your question.
Thank you, Angela. Thank you, Kanyari.
Just a minute, confirm, Gabriel, confirm that you can hear the one who is speaking now.
Chair, no, we cannot hear. I don't know.
So I can be loud. I can shout. Gabriel, you can hear me now?
Mr. Moko is very ready to shout. So let's see if you hear him.
I can be heard. Thank you. Thank you.
Yes, yes. Yes.
Okay, thank you. Thank you, Mr. Kanyari, for the very, very wonderful presentation. I came to for these functions primarily to also get the exposure and practice in the regional courts. And I must say that you've done a wonderful job this afternoon. And thank you for that. So I have a few reservations about practice in the regional courts. Probably we'll also address it as lack of powers up. Number one, I tend to think that trying to enforce international and regional law is kind of soft power that doesn't have a direct bearing on implementation of these decisions, the same way the national courts would, for instance, national courts decision would be implemented directly as they apply to the specific individuals, specific offices, and there are specific remedies attached to that. I'll give maybe 2 examples, and probably you are aware of them. Mother Karua went to the East African Court of Justice and all the way to the appellate level, and she got relief. But you understand that the relief she could have gotten in the Kenyan judicial system probably is different from what she got at the ESJ. And I tend to think that the relief at the regional level, as you have rightly pointed out, is that it is more of political coercion than the government now, which is usually the respondent, might or might not respond directly. It might choose to disregard, and the only consequence is political consequences. The rights of the affected person will continue to be abused. The other one is the one that the European Commission in the European Court of Justice delivered a judgment recently on Castor Semenya on the DSD regulations. Given that the applicable bodies, that is the CAS, the Court of International for Sports, and the Olympics Committee, the International Olympics Committee, has already taken a position. What would be your thought on how this ESJ, the European Court of Justice decision, how effective would it be in the running of sport generally? Because apart from the International Committee of Olympics, this one will probably precipitate to the other international sports organization. Now, do you think international law is doing enough in cementing rights, and especially the sexual and gender-based rights? That's just my 2 cents.
Yeah.
Wait, before you answer that question, there was another hand up there. Yes, yes.
Okay, my name is Natasha Monari. My question is just because we've talked about strategic litigation. I haven't had a mention about persons with disability. Is there any talks about the issue? Because they're also excluded in all these other issues. That's the only question I have.
Then one last question. then you'll answer the three before you wind up your presentation.
Yes, good afternoon, evening. My name is Okanga Felix. I want to marry my question with what he has asked on the political goodwill on enforcement of these decisions coming from the regional mechanisms. African problems, will agree, it's not the lack of institutions, but it's the lack of political goodwill to enforce and to realize or to empower those institutions, okay? So as he has asked, while the mechanisms allow for individual parties or litigants, most often than not, the respondent to those proceedings will be the state. And then you'll get your pronouncement or your judgment in your favor, but it's the state to enforce it, as you say. Now, where is the balance between the political goodwill, a state that you've sued, and you're telling them now enforce the decision from that regional, mechanism, be it the commission, or the courts, and how then we make sure that there's not there's a clear distinction, or the regional mechanisms can ensure, other than the shame and name and shame, what more can be done? What more can be done so that we realize the effectiveness of these mechanisms?
Yes, you can answer that first round of questions from participants who are present here physically. To our members joining us virtually, please feel free to ask any questions. You can type your question on the Q&A section, or alternatively, you can raise your hand, then we shall enable you to speak and you will ask your question live. Back to you, Mr. Kanyali.
All right, so participants online, can you hear me? I don't want to leave anyone out.
Yeah.
All right, there we go. So let me just answer a couple of questions. I think that the question of enforcement of decisions, Mukwe, is a very important one. And as time goes by, we are of course seeing a lot of like incongruent, like different decisions are coming up with like contradicting outcomes. So like you've talked about the Casa Semenya case. I think in that particular case, I really don't know how the implementation is going to look like, but I suspect that they will try to kind of states over time will coalesce between choosing one side or the other, and then like the person who gets the most state support perhaps will have like the more leverage in terms of kind of like reversing a specific decision. And of course, that is not an effective remedy for CASA in this particular case, because it prolongs like, the timeline for the implementation of that particular decision. So for example, like I feel like the only way that decision by the European court can be affirmed is if actually the IOC court will just kind of like choose, or the IOC itself will choose to actually be bound by that decision. But that again goes to the question of goodwill that my colleague has spoken about just now. I would say that, I mean, like to enforce these decisions, it takes a lot. Like, I think that there was a time when these mechanisms were being set up. If you think about the time the ICJ was set up, like there was real hope in terms of like fighting state impunity, where like states would just kind of like be compelled to kind of like, conform to certain decisions as a matter of law, and also as a matter of their treaty-based obligations. But now what we are seeing that's become quite, we can't rely on states to just do that out of their own goodwill. I will say that even the name and shame mechanisms that I've spoken about, for example, for the African Commission, they're extremely difficult to enforce because the Executive Council of the African Union, which is made up of, I think, the foreign ministers of all the EU countries, like, will not want, for diplomatic reasons, they don't want any of them to be named and shamed, even if you're not in that name and shame list. And of course, for those who are in the name and shame list for the EU, they lobby other countries to fight their inclusion or the publication of the fact that they've not been implementing decisions. So I think it's upon us to start thinking about innovative ways of pushing governments to challenge, to implement decisions, even where they're adversely affected. I think that if there was, you know, kind of like a mass coalescing of public opinion to kind of like push governments to implement these decisions, then the government would definitely feel pressure to, like, a lot of public and political pressure from their own citizens to implement these decisions. And how I think the European Court functions, because I think it covers countries who are both EU and non-EU members. I feel like how it's been able to do it is just by kind of like tying implementation of a specific decision with your ability to enjoy some of the benefits of being part of the EU or having a relationship with the EU. And that, what that has done is that is actually brought in another level of complication for this work. So for example, it is well known that Russia has a budget line item in each year in its budget. It has a line item for compensating people who've been, people who've taken Russia to the European Court. So it will kind of like go through the plaint, and then the person will be like, okay, I'm demanding 100,000 euros from Russia, and this other one is demanding 50. So they'll add up the money and then they'll appropriate in their budget, because they'll be like, yeah, we'll just go ahead and pay the fine. So we've seen even countries like Russia, which are kind of like, you know, fundamental violators of human rights, that there's a way in which, like, once you bring in that political leverage, there's a way that you can get governments to enforce the decisions. But I mean, I'm not going to lie to you, Mukwa, that where we are as a country and as a continent when it comes to the rule of law, human rights and democracy, we haven't gotten to the point where, like, we would even envisage sanctions. And this doesn't even mean just financial sanctions, but also kind of like, you know, that preferential access that you usually get as part of being in a community of states. We still aren't at the place where we can start leveraging those. I will say that now, because the AU differs to regional economic communities when it comes to the enforcement of sanctions and other kinds of political accountability mechanisms, I think that with time, the EACJ, like, will get to that place where perhaps we can start leveraging some real kind of like threats to ensure that the decision is implemented. But that's why I was saying that public interest litigation doesn't stop once you've won or lost a case, that you need to kind of like keep building that public interest in ensuring that the government does the right thing in, you know, for example, addressing a wrong or implementing a decision by these mechanisms. I would personally, for me, I would say that go to the regional redress mechanisms after you've exhausted all local remedies, because it's much easier to kind of like enforce a decision, you know, like secure the fruits of litigation nationally than it is when you go to the EACJ or the African Court. But usually the main reason why strategic litigants pursue these courts is the precedent setting opportunity, and also the fact that these courts like usually have policy recommendations. I worked on this case, which in my previous job, where it had been going on for 10 years. And like, we know for a fact that the government in question, the government of Ethiopia, will never kind of like pay reparations of $100,000 to the victim in question. But we do know that we can kind of like try to do a lot of advocacy to see whether they can implement other aspects of the decision by the African Commission in that case. So for example, they talked about training of judicial officers to prosecute sexual offenses better, and also like reforms to the law. And actually the law reforms that were demanded by the African Commission have now been put in place in Ethiopia. So again, strategic litigation, sometimes it takes 10 years to like litigate. It's probably going to take another 10 years just to enforce the decision. It's not easy. And it's actually, thank you for bringing that question up so that I can also keep making it aware to the people who want to litigate these issues regionally. This is not a short affair. You are in for the long haul. So yes, sanctions, maybe we need to kind of like get people to start supporting sanctions like as a means of political coercion. So today Natasha, we were mostly talking about litigation in general for SRHR, but of course, persons with disabilities also have a diverse range of SRHR needs. There are a lot of case law that comes out about things like forced sterilization, for example, access to education, even just physical aspect, access to certain kind of like buildings or spaces. So I would say like everything that I've spoken about here today, like you can just pick it up and like say, okay, I want to work on girls' rights to education and the information will be relevant. I want to work on PWD issues and it will still be relevant. And now I think that there's a real opportunity to expand the work at the regional level, because we know that the African Commission, a few years ago, they came out with the Disability Rights Protocol. So that again adds an extra layer of enforcement and more specificity on what the needs of persons with disabilities are. Yeah. How can we secure implementation? What more can be done? I don't know what from my own Kenyan experience when it comes to building political support for human rights issues. I think I don't know what happened to this part of the world, but getting that kind of support is very hard. We are not the only people who sue governments at regional mechanisms. They do it in Europe, they do it in the Americas, they do it in Asia. But for some reason, there's a lot of apathy towards the outcomes of these decisions. And this goes back to the discussion on, how confident are people, how much confidence do people have in redress mechanisms in the first place? For example, in Kenya, there's a lot of mistrust of the judiciary. There's a lot of mistrust of political institutions. There's a widespread belief that every institution continentally is tainted with corruption. And so like, I think what happens is people are like, why bother? Why bother supporting this thing? So, I mean, even building the enabling environment for full implementation of SRHR or any strategic litigation decisions, it will take educating the public about the importance of actually caring about these things and caring about the fact that the government is compelled by treaty law, by constitutional law, and by statute to respect the decisions of judicial organs. So that's I wish I had an easier answer for this. I wish we could like go and with a stick and tell the government, okay, we need you to implement this decision, but we can't. They have a bigger stick in most of the cases. Yeah, so I want to just talk a bit about a good, you see, once you mention sanctions in Africa, gosh, like big trouble. I'm not going to, I spoke about gathering evidence. There's something happening with my PowerPoint, but we were talking about selecting the appropriate redress mechanism. Angela, was there any question in the Zoom?
No.
All right. We talked about developing a litigation strategy. Is it?
Yeah, we are doing something.
All right. Okay. We talked about mobilizing support. How do you mitigate risks and challenges in litigation? Number one, you have to identify actually what the legal risks are. And in terms of okay. Gabriel, can you hear us? Hello. If you can hear us, colleagues, just post on the chat section. It says it shows a 9.
Someone needs to confirm that we can continue.
Oh, they've confirmed.
Yeah, seems like the one who can't hear had an issue with their device this person.
Okay. So how do you mitigate risks? Number one, you have to ask yourself, what are the potential risks? So there's a huge risk, for example, in backlash and reprisal. Usually when you sue the government, there's a big risk that they are going to engage in certain reprisals against you. Again, that shouldn't happen if we lived in a utopia where we believe, governments are accountable to the same laws that they pass, but it happens. I think that if you're working on extremely controversial issues, it's good to establish safety and security measures. Think about the strategic partnerships that you can have so that people are backing you up when you're in trouble. That's one of the main reasons why in strategic litigation, you're advised to work with a diverse set of organizations, experts, and other actors. Public engagement and support is a good way of mitigating risks. Usually the government in certain instances won't want to touch you when you have public support for the work that you're doing. Again, maintain legal expertise and resources. So, you have the lawyer who's doing the strategic litigation. Do you have the lawyer who's defending the rights of the litigants in case they face reprisals from the government? What are you doing, like in case of arrests or countersuits or administrative attacks on CSOs? And especially if you work in SRHR organizations, we are living in times where there's a lot of extremism against basic provisions for reproductive and sexual rights. But like you find that, you need that kind of backup in terms of practically helping people who are in trouble. How do you document and manage evidence of some of these risks? Is this something that you have at the back of your mind, or have you actually noted it down somewhere so that you can map trends over a certain period of time? What are you doing in terms of advocacy and public relations? Again, strategic litigation, it's at the low courts, but also the court of public opinion. So what are you doing in terms of managing what the public thinks or knows about the case? And then are you continuously monitoring and evaluating the progress, impact, and challenges that you face during the litigation process? Again, strategic litigation is not just about filing a case. You have to keep tabs on the case. You have to keep tabs on what people are saying. You have to keep tabs on what the government is saying if you're suing a government, for example. And all of that is very important, like for mitigating risks. Yes, I'm winding up now. I wanted to give you a small snapshot about a case that was done right. This is not the only SRHR case in a regional redress mechanism, but this case has everything that I've discussed to the questions that have been asked in the plenary. So this is the case of Legal and Human Rights Center and Center for Reproductive Rights v. Tanzania. I was asked to do a presentation on regional redress mechanisms. If it was national redress mechanisms, I would have probably done a Kellyn case or a case more directly involved, kind of like involving the East African Law Society. But this was a case where complainants they underwent forced pregnancy testing and expulsion if they were found pregnant or married. So we are talking about girls here. And as you can see from the case, girls as young as 11 years old were tested. So the litigants, again, provided statistics. You see, that's very important. So they went and looked at Tanzania's own statistics. And they were like, the Tanzanian government had said, in this particular year, about 2,400 girls had dropped out of school due to pregnancy or marriage. But then they also went and looked at other research that's done by, for example, the Human Rights Watch, where they found that over 15,000 girls drop out of school every year in Tanzania due to pregnancy. But then CRR had done its own assessment and found that 55,000 female students dropped out between 2003 and 2011. I want to just point that you don't have to have, you can bring in different statistics. And that also kind of like supports your case somehow. because you can say the situation is so shambolic that we can't even know how many girls are being affected by the policy of Tanzania to ban or to expel pregnant and married schoolgirls from the education system. So they went and they looked at what are the testing methods. And then they found that the testing methods lacked standards and can be painful. They were done without a girl's consent, and the results were not shared with girls. So they shared, but the results were shared with the school staff without the consent of the person actually who was being tested. And I know for some of you might ask yourself, oh my gosh, like, was it really that bad? Like, you know, it's just a pregnancy test. Like, this is the Kenyan style pregnancy test that all of us have heard about in high school. Poking the belly, very invasive vaginal exams, kind of like, you know, you're taken through what is, I think in the Inquisition, they called a trial by fire, where you're interrogated aggressively to find out whether you're pregnant. And woe unto you if you are found to be pregnant in the first place, because the case found that you are being detained for prolonged periods of time until you divulged the name of the person who, you know, contributed, so to speak, to the pregnancy. So like you found that that was a big kind of like case in Tanzania. And then once you're found pregnant, you're expelled, of course. That was as a matter of course. And then if you are married and you're a girl and it's discovered that you're married, you are not allowed to register or remain in school. And this was against provisions of the Tanzania Marriage Act. And of course, expelled pregnant or married schoolgirls were not readmitted to public schools after, let's say, the marriage was terminated or annulled, or after you completed your pregnancy. So, and then you are limited to just going to private or vocational training schools. And then they found that the education rules for the imposition of penalties to persons who marry or impregnate a schoolgirl penalize those who marry or impregnate a schoolgirl, but that was never applied. Like, it was rarely applied that, you know, the sanction should go to the person who, quote unquote, impregnated the schoolgirl. But in practice, there was a contradiction that the person who faced the most reprisal for being pregnant or married is the girl in question. And then during the case, the government made statements and inaugurated new policies which sought to intensify efforts to expel pregnant students and prevent their readmission. So those are just the basic facts of the case. So I'm not gonna go into a big chunk of the admissibility, but of course, these regional mechanisms, before they start looking at the merits of your case, they have to decide whether your case is admissible. And to just make your life a bit more difficult as a litigator, they don't tell you it's admissible or not until the case has concluded. So you'll be there like really working hard, doing the best research, and then they tell you, okay, like your case was not admissible, we're sorry. So these are the rules. We've talked about how NGOs are allowed and individuals are allowed to litigate at the African Committee of Experts on the Rights and Welfare of the Child. So this is where the case was located. They found that the domestic remedy of the case in question lasted over 7 years, but the appeal stage was still pending. So these guys had not exhausted the 7 years for kind of like, you know, that timeliness doctrine. But then the appeal stage was still pending, and the appeal was taking a very long time to conclude because they had, you know, taken this case to the Tanzanian court system, and I guess they failed at the High Court, so they appealed at the Court of Appeal. And in kind of like coming up with the admissibility argument for this particular dispute, the Committee of Experts actually applied the principle of best interest of the child. And that was just to kind of like expedite matters. And of course, they found that the submission or like the case, the communication had been had been filed in a timely manner. But of course, the Tanzanian government argued that the case was premature, it was misguided, and it misinterprets the requirement for admissibility. So the committee found the communication admissible. And I think actually, just to give you a sense of some of the things that can, when you say that the remedies are ineffective or they've been exhausted, complainants attempted to engage domestic courts, but the waiting period was excessive. That they had been waiting and waiting for this case to be dealt with at the Court of Appeal, but nothing was happening. So that was a good reason for them to escalate the case to the committee of experts. I'm gonna try and rush through. All right. So submission on the merits, like we had, I'm just gonna talk about the rights that were said to have been violated by the Tanzanian government by the complainants. And that was number one, principle of the best interest of the child. Let me tell you, like this principle goes a long way, like in kind of like securing a decision, because like it's universally recognized that you need to protect the best interest of the child. So they talked about the right to education, that this the policy and the practice was against the rights of education, equality and non-discrimination, protection from harmful practices and stereotypes, to health, including access to SRHR, privacy and dignity, and freedom from cruel, inhuman, and degrading treatment, and also to general measures of implementation. And we'll talk a bit about that as we proceed. So, of course, Tanzania denied violation of the charter, the African Children's Charter. It talked about its efforts to provide free primary and secondary education despite limited resources. Oh, and just to note, some governments are very, very diligent in pursuing a case. So depending on the government that you're up against, it can really determine how, you know, like the chances of actually winning a case. Some governments don't even do submissions. They're like, well, I'm not engaging in this process. But the government of Tanzania, because they have the African court within their own borders, and they're also very active at the AU stage. They're very diligent in pursuing litigation. So that's also something that you need to keep in mind. You need to know what the other side is also bringing. The Tanzanian government argued for a margin of appreciation in education provision based on prevailing circumstances. So it was like, please give us a small break for us to promote the rights of education for the people who are not pregnant and who are not married. That was an argument that they used. And then, of course, they asserted their prerogative to limit the rights of schoolgirls to achieve certain outcomes. They asserted the state's responsibility to promote African values and morality in the education sector. And of course, they said the expulsion of pregnant and married girls were meant to discourage sexual relations among children. So, and then it submits that the limitation on girls' rights serve a legitimate aim considered relevant and sufficient. So it's good to also know like what the government is going to be saying. All right. In conclusion, so what did the court determine? So first of all, on the detention of pregnant schoolgirls, it found that the detention, it violated the principles of illegal detention, also infringed on the right to dignity and physical integrity. And of course, it also noted for cases where the schoolgirls in question were detained for being pregnant on account of sexual violence or a rape, it exacerbated the trauma and violated their rights. So again, they go down there, forced pregnancy testing, expulsion, and illegal detention violated Article 16 of the Charter on Cruel, Inhuman, and Degrading Treatment and Punishment. On the issue of the right to education, they found that the expulsion with no re-entry violated Article 11, and that forced and mandatory pregnancy testing also violated Article 11. And then the measures that the government was arguing were within the margin of appreciation. That was found to be unjustifiable. Let's continue. Yes. Talking about gender discrimination on expulsion, again, they found that the expulsion, denial of entry, mandatory testing, and detention were discriminatory, also taking time to kind of like distinguish the experience of pregnant schoolgirls versus the experience of their alleged, kind of like the people who were said to have impregnated them. So they found that there was a discriminatory element there. And they've also found that the measures by the state, including the policies they put in place, the statements by the Minister of Education in particular, and I also think the statement by President Magufuli at the time, were said to perpetuate gender-based discrimination. Again, mandatory testing, expulsion, and detention were found to have constituted harmful practices, and the practices were harmful not only on the effect of the victims in question, but because they also perpetuate discrimination and hinder justice for victims. What did they say about best interest of the child principle? Again, they talked about the mandatory testing, expulsion, and denial of re-entry into the school system as violating Article 4. They found that the state failed to consider the best interests of the child. That's a very, it's one thing to say that you violated the provision, but to also go ahead and say that in your formulation of the policies and practice, you also did not consider the best interests of the child. That's very important. So 1 minute, let me do it in 1 minute. Again, it was found to violate the right to health. Again, the state measures were held to be insufficient, and the obligations must be fulfilled to protect children's right to health. I'm about to finish, Angela, don't. Yeah. So on the right to privacy, again, you remember that you would have the so-called test done on you as a pregnant schoolgirl, or even like, you don't have to be, because the testing is so wide, you're being tested even when you're entering the school system. So regardless of whether you've even been suspected of being pregnant, that the mandatory testing and then the follow-on illegal detention and criminalization were also a breach on the right to privacy. Of course, adding the element of the fact that you were tested, but they didn't tell you the results. They would tell, for example, school administration officials or parents. And then also, like, this is a big one where Article 1 of the Children's Charter states that state parties are required to undertake legislative and other measures to realize the provisions of the Charter. It was found that the state was below minimum standards, but even in the case where it had fulfilled the minimum standards, that doesn't stop you from going above and beyond in terms of protecting children. They found that the legislative measures, especially like in the regulations, education rules and education regulations, were regressive, and they failed to prevent child marriage. And of course, the state, Tanzania, violated its obligations under Article 1. I'm not going to go into, they talked about recent developments, because I think at some point the government of Tanzania sat down and was like, I don't think this case is going well for us. We need to do something to show the courts that we are doing right by our policy. So they released a circular by the Ministry of Education in November 2021, and the circular allowed readmission within 2 years for girls who dropped out due to pregnancy. But they said if you were expelled as a girl for disrupting like the education of other girls, you are not allowed to go back in. And that's very important for you to keep at the back of your mind, because a lot of the reasons, as we spoke, for why these girls were being expelled was due to morality, or like you're depriving other students of the chance for an education. So when you put that proviso to say that if you are expelled because you are disrupting other people's learning, you're not going to be allowed, that also leads to certain limitations for pregnant schoolgirls. So what did the committee say about the circular? Does not address the main issues raised in the communication, lack of clarity regarding the situation of expelled pregnant schoolgirls, and then the time limitation. That's very important, because I mean, this is a case that has been going on for quite a long time. So even the complainants in the case could not have benefited from the circular that was issued by the Ministry of Education. So there you see the time limitation was faulted as well. And then exclusion of students expelled due to criminal cases contradicts the purpose of the circular. And of course, there was no indication that the inconsistent rules and policies that form part of the litigation would be repealed. So the circular didn't talk about that. So they found that the committee found that the response to the issues raised in the communication by the circular were inadequate. And so they went ahead to issue the decision. And the decision is, as you might think, which was, it recommended, the prohibition of mandatory pregnancy testing, for example, the review of these rules that locked girls from accessing education because of wedlock, It allowed the reentry of schoolgirls into the school system. And then think about like the quality of this decision where they talk about the government was, the committee recommended that the government provide support programs and better learning outcomes for readmitted girls, as well as clear guidance to school administrators regarding re-entry of pregnant and married girls. You have to investigate cases of detention as well. You have to provide comprehensive sexuality education and child-friendly health services, and sensitize, teachers, healthcare providers, police, and others. You have to take proactive measures as the Tanzanian government to eliminate child marriage and harmful practices, and establish reporting and referral mechanisms for survivors of sexual violence, and provide support services. If the Tanzanian government simply carried this out, there would have never been the need for a case. So we don't bring cases because we want to win a case at the Africa Committee of Experts. We bring them because there's something that the government hasn't done and it needs to be remedied. Had they done this in the first place, there would be no need for us to engage in this litigation. And of course, there's everything from investigating perpetrators of sexual violence and child marriage, taking action against forced pregnancy testing, and providing special support for pregnant and married girls. And then lastly, the government of Tanzania was ordered to report on measures taken within 180 days of receiving the committee's decision. Tall order, but we try. There are some other cases I had wanted to talk about, but I won't. So for example, we have a similar case in Sierra Leone, with similar facts of the expulsion of, pregnant and married schoolgirls. Yes. Yes, we have one on, forced sterilization. We have another one where the government of Uganda was compelled by the Constitutional Court to actually increase its budgetary appropriations for maternal health. And the Constitutional Court of Uganda actually had a specific figure in the judgment that it wanted the Ugandan government to appropriate for maternal health. And then, of course, we have the FIDA standard and guidelines case, where this one is also a landmark decision in the sense that the High Court did not take into consideration Kenya's reservation to the Maputo Protocol when it comes to abortion access. It just decided on Article 26 sub Article 4 of the Constitution. So that's to just see that the courts are very empowered to go beyond what the government has set itself for itself as the limit, and actually enforce constitutional provisions. So what are some of the best practices that you saw, for example, in the Tanzania case? Number one, research and data are key to successful litigation. I would urge you to just read the case to see how these regional redress mechanisms go about determining a case. It is important to center victims of violations in the litigation. It shows courts that violations of rights affect real people. So for example, you saw with the African Committee of Experts that they were actually quoting the words of the girl litigants in the case directly, and saying, for example, we were never taught how to avoid, getting pregnant or catching HIV. We were just told, don't get pregnant and don't get HIV. So that shows you the limitations in education and access to information that would have probably prevented the girls from becoming pregnant in the first place. You have to be clear on the remedies sought and their legal basis. In this particular litigation, if you notice, CRR and the Legal and Human Rights Center, they didn't go for cash reparations. For them, they wanted a change in policy and practice. And that is what they pursued in this particular case. And so that's when you focus on one remedy or a set of remedies that you want out of this case, and you have a clear understanding of how those remedies will improve the situation at hand, it's much, much better for you to it's much easier for you to get those remedies in the first place. And of course, collaboration among multiple CSOs and experts is key. Usually for these strategic litigation cases, it's rare that one organization will sue. It's good to partner. You don't know everything. try to kind of like work with other organizations who have similar interests, and you'll see a lot of wins. And then, of course, forum choice is important since the forum determines what remedies a litigant receives, as well as how to enforce or implement the decision. And just to conclude on this, I will say that, I mean, there was this case at the African Committee of Experts, but the outcome of a similar case at the African Court on Human and People's Rights was very different. And you can think about all manner of things that went into, what's the difference between the decision of the Committee of Experts and of the African Court. Similar facts, similar country, Tanzania, similar, legal basis and legal justifications and legal arguments, but very two different outcomes. That shows you that you have to be very, very specific and very careful when it comes to forum choice. And in those two cases, the involvement of the Tanzanian government was very different. You can see here, they talk about the circular that they released when they realized, oh my gosh, this case is not going our way, but they didn't do the same for the African Court case. So that's just to show you that you have to really, if you're going to live with anything here, and this is strategic litigation for any thematic area, you have to do proper prep, you have to do your research, you have to have intricate knowledge of the dispute at hand and what you want to get out of the courts. You have to center a specific person or group of people in your case. If you don't do that, the courts will just say that this is a hypothetical case. How do we know that this thing has happened in the first place? You're just arguing on hypotheticals. Of course, that's different from one jurisdiction or one forum to the other, but, proper planning, you have to have a, kind of like a horizon view. You're like, okay, we will file the case. The case will take certain years to finish. After it finishes, now we have to think about implementing the decision. So forum choice, all of those things, very, very important in doing a very successful strategic litigation case. The good thing about one of the organizers of this training session this afternoon has won a lot of cases, and that's Kellyn. So if you want advice on how to win cases and secure victories, I think Kellyn is the place to go. So that was my presentation. I've talked about some of the key takeaways, and now I open the floor for questions, comments. Yeah. Thank you. Thank you, everyone.
Now, members here clapped before I told them to clap, so you will clap again for our speaker. I think you'll agree with me that this has been a very informative session. The session was to be 2 hours. We have exhausted the 2 hours. This is one of the advantages of having a speaker who is very, very knowledgeable in the topic that he's speaking to us about. So in the interest of time, we shall allow just one question or one comment, one from the online participants and one from our participants here in the room. And if you don't volunteer, you see, one of the powers of being a moderator is that I can volunteer you. And we have someone in the room who has come all the way from Tanzania. Remember, this session has been facilitated through a collaboration between Kellyn and East Africa Law Society. So she cannot come all the way and then we fail to hear her voice. So just tell us something. And you need to speak up because for some reason we don't have a roving mic.
Okay, thank you. My name is Reproductive, as she said, I'm from Tanzania.
You need to say your name a bit slowly so that we hear it. I hope members online, you can hear the whoever is speaking now. Just type on the chat section, or Gabriel, or Dani, tell us whether she's audible.
Okay, I am Reproductive. Yes, I'm from Tanzania.
a member from Tanganyika Law Society and East Africa Law Society. Yes, I was here for African Law Tech, but when I was on the way here, I saw the advert on training on this strategic litigation of sexual and reproductive health rights. And I am part of the 10 members in Tanzania, 10 women who are defenders of sexual and reproductive health rights. So I decided to request to join this session. And I'm glad that I've given the opportunity, yet I'm here. I also like to thank the presenter for the informative presentation, and I'm glad that I learned a lot. But when I was listening, I was about to ask the question, but on the way he answered it, it was about when we leave alone this local remedies that a person wants required to exhaust before taking the matter to these African courts, maybe. What are other criteria which will lead the case or the matter to be inadmissible? Also, I was so glad to hear that one among the cases which you presented is from Tanzania. Though I didn't come across it, but in Tanzania, maybe I can add some, I don't know, what can I say, maybe experience that most of the cases which are having a violation of this, wherever human rights or whatever sexual and reproductive health rights, that's from it become a criminal case. So those who are prosecuting it almost it is a government. And most of the time, the cases are maybe dismissed because of such of technicalities. So the matter did not come to an end on its merits. Now, I was asking myself, we have a lot of cases, for instance, incest cases, which have been dismissed before the court for technicalities. And those people who are claiming for their rights, they didn't get the remedy as they expect. Now, assume that we have such kind of cases. How do we help them, or how do we start to initiate the strategic litigation cases through that cases which have been dismissed from the court? Maybe that can be my question, or whatever suggestion or recommendation which you can add on it. Thank you.
Thank you very much. I hope our participants online, you have heard the question. There is no hand up from the participants online. Anyone with a comment, as we allow our speaker for the day to answer that question and to give his closing remarks. I have been informed that this is a talk on human rights, so I cannot volunteer anyone. You have to volunteer. As we wait for people to volunteer, Mr. Kanyali will answer that question and give your final remarks.
Right. Thank you, Angela, for that. I will say Tanzania has been a very instrumental place for all right, so Tanzania, again, just to repeat, has been a good country to look at. You know, when we say that the remedies have been exhausted or the local remedies are ineffective, what do we mean when we say that? And I think that in that particular description that you've given us, in cases where you have a lot of incest cases where like the case is thrown out on a technicality, I will say that that actually is an instance where like the local remedy was ineffective. The case of incest has happened. The case is thrown out not because of like a normal conclusion of the case, it's thrown out on a technicality. So no justice has been done. It's just that everyone has gone back to the position that they were in before they approached the court, especially in the case of the victims of incest. So there, I think you have a good case to talk about ineffective remedies. One of the other tactics and strategies you can use, again, is you can do research and get a deeper sense of how, in what ways these remedies at the local level are ineffective. So for example, I would be surprised if a court like the African Court or the African Committee on the Rights and Welfare of the Child, like if you give them, like, for example, 5 cases or 10 cases where the case has been thrown out on a technicality in the same way, I doubt that they would not consider that to be ineffective remedies for victims of incest in Tanzania. And even like, I know right now at the African Court, there's a case going on of NGOs who were caught in Tanzania doing training, and they were kind of like training local activists on how to litigate against the Tanzanian government. So of course, the Tanzanian government doesn't like that. And in that particular case, you had, because there were foreigners involved, some of the foreigners were actually deported from TZ. So in that particular case, you see the government has already done your job for you. You don't even need to do that much research to come and say that the local remedies are ineffective, because first of all, you don't have access to the courts when you're deported. You cannot file a Tanzanian case when you are physically outside Tanzania. I doubt that there are provisions in place for you to be able to do that. Even if you hire a lawyer locally, things like, you know, giving witness testimony and so on and so forth, very difficult to get done. So just look at what the government is doing or what your opposing side is doing in terms of limiting your ability to secure the justice that you need at the national level. I will say though, that my advice and my recommendation always is you need to take the case nationally as far as it can go before you attempt to kind of like escalate the case to the regional or continental level. Because if you didn't do that level of due diligence in the first place, you're just jeopardizing your chances of winning at, you know, kind of like the redress mechanism at the regional and continental level. Yeah. I don't have any closing remarks. I would say that every time I talk to lawyers, I think it's good. You know, lawyers, we are a very insular group of people. We want to hang out with other lawyers. In certain instances, we actually even only respect other lawyers because we think, oh, these are the only people we are intellectually similar to. I would say try, and if you're interested in this strategic litigation work, I think Kellen will tell you that we can't have too many lawyers who are interested in using the law as a tool for social change, or the law as a tool for constitutional implementation. So there is a true shortage of lawyers. We need more pro bono lawyers. We need more lawyers who are, you know, have deep, you know, connections with the community so that they can kind of like bring out some of the issues that are coming up. Natasha had spoken about, you know, the rights of persons with disabilities. So like you have to kind of like have a lot of good relationships with the community. You have to be serving the community to kind of like tease out some of these issues that have not risen to the national level yet. And also, you know, just keep reading up. The joys of law is that you can read about any law from any country concerning any legal issue, and you wouldn't feel like you're out of your depth. So if this is something that you're interested in, I would say just keep reading widely and trying to figure out where your intervention will be. And of course, as always, I wish you the very best in your endeavors. Thank you.
Again, you have clapped before even the claps. Can we give a final round of applause to our speaker, Mr. Kanyali? what we are running down only in a small claims court. We have been challenged that there are other forms of litigation apart from conventional litigation, especially small claims where you just fill a form and you do submissions under Section 30. But I would really like to thank the speaker for giving us the necessary tools and for challenging us that it's possible, and we have been informed that there is a shortage of lawyers in that space. So now that we have the necessary tools, let us not be afraid to be champions of social justice or social change. With that, I would like to thank our speaker. I would like to thank Kellen, and I would like to thank the East Africa Law Society for facilitating this very, very informative webinar stroke seminar. Please look forward to more events, more similar events. We are trying our best to do more physical events. This time we have started with Kenya. Maybe next time we'll go to Uganda or elsewhere. There have been very many requests for the slides and for the presentation material. Number one, this webinar has been live streamed on all ELS social media platforms. And remember, before you attended this webinar, you registered, so the slides will be sent to the participants via email. With that, enjoy the rest of your evening, and let us continue being champions of change. For those who are joining us virtually, imagine you are taking a cup of tea, because us who are here will take a cup of tea after this. With that, we have come to the end of our webinar. Enjoy the rest of your evening. Thank you very much.
Thank you.
Now you clap for the moderator. Thank you.